Do you want to learn more about Virginia protective order law? Hey folks, my name is James Abarinio. I'm a personal injury and criminal defense lawyer here in Virginia. And in this video, I wanted to explain how Virginia protective orders work. Simply speaking, Virginia protective order is an order by a court saying to one person that you need to have no contact and other uh, conditions when it comes to your behavior towards another person. Other states call these restraining orders, no contact orders. In Virginia, it's called a protective order. And generally speaking, in order to get a protective order against another person, you have to demonstrate to a court that a person has committed abuse against you, and in order to protect your safety, the court should order that person to stay away. And if that person ends up violating that protective order, they can essentially be charged with a protective order violation and have criminal sanctions imposed against them, as well as other sanctions. So that's at the 1,000-foot view what we're talking about here. In order to more orient our discussion, I did want to reference a website or article that we have drafted here at Abarinio Law. It's titled "Learn About Virginia Protective Orders." In this, I'm really going to kind of reference a few specific points just to kind of get the law across. Again, this is educational. If you're seeking a protective order, or if somebody's seeking one against you, with anything, you should seek legal advice directly about the facts and circumstances of your case. So just going back, a protective order in Virginia can be obtained, and let's talk about it from the petitioner side. You can seek a protective order against somebody who is your family member, so it can be a significant other, it can be a family member. But also in 2011, Virginia expanded its statutes to allow you to be able to get a protective order against somebody that is not your family member. So if you may not recall, tragically in 2010, there was a UVA student, Yardley Love, who was murdered by her not significant other, but I guess an ex-boyfriend. And because the way the protective order statutes were written before this, because he didn't count as a family or household member, you could only get a protective order against him if you were a family or household member. Now they've, in 2011, they expanded that rule to allow the ability to get a protective order against somebody that is not a family or household member, so long as they've committed abuse or act of violence. Now, to get a protective order, the petitioner has to prove that the respondent committed abuse, and that order, the protective order, is necessary to protect the health and safety of the petitioner and family or household members. So how do you define abuse? So just stepping back a moment, I think depending on whether or not you're talking about seeking a protective order against a family household member versus a non-family household member, take a look at Code Section 16.1-279.1. This case is dealing with family or household members. If it's a non-family household member, take a look at Virginia Code Section 19.2-152.10, dealing with non-family members. And when we're looking at the definition of actual abuse, for family members, it's Virginia Code Section 16.1-288. So a family abuse is an act of violence, force, or threat that results in bodily injury or places one in reasonable apprehension of death, sexual assault, bodily injury. And then it goes on to say such act includes but is not limited to any forceful detention, stalking, criminal sexual assault, or any criminal offense that results in bodily injury or places one in reasonable apprehension of death or sexual assault or bodily injury. Now, when it comes to the non-family household members, we're looking at Virginia Code Section for abuse. The definition is Virginia Code Section 19.2-157. 152.7:1, and here I've actually linked the statute, and just so you can see a little bit more specifically, act of force or violence means any violence, force, or threat that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury. Such acts includes but not limited to forcible detention, stalking, criminal sexual assault, and again results in bodily injury or places somebody in reasonable apprehension of death, sexual assault, or bodily injury. So pretty comprehensive list. We'll go back now. Now, I did in this article provide also cases where the term abuse has been litigated. So here, Stevens versus Rose. This is a Virginia, looks like Supreme Court case, found abuse occurred without direct act of violence or threat. Stevens' case involved an ex-boyfriend who called the petitioner 40 times in a short period of time and showed up to her father's house, her house and her father's house unwarranted. And so the Virginia Supreme Court, in granting that, found physical harm or threatened physical harm to a victim is not necessary prerequisite to the granting of a protective order. What's more, a victim need not specify what particular harm she fears. So I would take a look at that case if you have any questions. And again, with this article, I've linked that so that hopefully is a useful resource. Again, if you are seeking a protective order, you're also going to want to demonstrate to the court that you have an ongoing need. So language used against you, like "I'll get you," you better watch out. There is close proximity or potential proximity to the alleged offender. And also your stated need of ongoing fear. I think that's also something that if you're presenting your case, you'll want to present to the judge. Next, a few technical points that I think the article helps lay out. If you're seeking a protective order, you're going to have to get the respondent served with process without proper service, meaning they've got to officially, by law, be advised that you're seeking a protective order, that there's a court hearing, and they have a right to contest it. Without that proper service, the court is limited in what it can do. It's kind of hard to get a protective order violation against somebody if they were never served with that protective order. So they need to be served. Now, the next question is, what forms of relief can be granted in a protective order? I've got a laundry list here. No further acts of abuse, no contact. That means no physical, telephonic, email, text, or indirect contact through third party. Granting the petitioner sole possession of a residence, requiring respondent to pay utilities, other things like that. Ordering the respondent to participate in treatment or counseling, temporary custody or visitation of minor children, granting sole possession of pets. So those are things that you, in addition to no contact, you can seek through the protective order. Also, something to consider when there is if the protective order is entered, what does no contact mean? There can be interesting litigation over whether or not the person had contact in violation of that protective order. I linked Elliott versus Commonwealth, an important case to look at. I think that in that case, there was an alleged violation of contact because the respondent placed himself to where he could be seen by the petitioner, and is that actual contact or not? You can read that case for yourself. But needless to say, no contact can be litigated. And how long does a protective order last? Generally speaking, in Virginia, 2 years if it gets granted. You can also ask for additional extension once that 2 years is coming to an end, but you have to file a separate, ordinarily have to file a separate motion for that. One thing to think about, if you get a protective order entered, generally speaking, you're going to file for protective order in either the Juvenile and Domestic Relations Court, the General District Court, which is the lower trial courts here in Virginia. If the protective order gets entered and the respondent appeals it, during the appeal, the protective order will remain in effect. So if you've gotten a protective order against somebody and they appeal it, just be aware that during the pendency of that appeal, that will remain in effect. If you're opposing a protective order and it's been granted against you, be aware that if you violate that protective order, you can't just say, well, it was on appeal. That's still going to be used as a protective order against you. So just be aware of that. Now, another point that I made is the parties can agree to dissolve the protective order. They got to get the court to do that, but just be aware that's a possibility if for whatever reason that was something that was important to you in your case. So obviously this article is not meant to be an exhaustive discussion. This video is not to be that you no longer need to speak to an attorney in your case. But hopefully this is a useful starting off point. If you have questions about a protective order case, feel free to reach out to us. I will tell you, we don't do family law, so protective orders involving children and seeking custody, we're not going to handle those kinds of cases just because I think a family lawyer needs to be involved in those, because protective order can in a lot of ways become a custody type issue, and that's just not something that we handle. But if you're seeking protective order against somebody, or if you have somebody's trying to seek one, we defend them as well. If you're doing protective order cases here in Virginia, you're probably doing both sides. And I think it makes better lawyers if you've both defended and pursued them. So hope this helps. Wish you guys the best. Take care.